And welcome back. We are moving into our first segment. Of course, a very touchy topic when it comes to the ruling of the ICJ. In with us is Magali Marin Young, of course, attorney at law, constitutional administrative law. I think I got it correctly there.
Senior counsel, of course.
Senior counsel.
Yes.
Good morning, and it's so nice to see you. And of course, welcome.
Good morning, and nice to be here.
Well, this is such an important topic for our viewers and for all Belizeans because it has obviously dominated the newscasts and I think the everyday conversation. But it is a very legal topic. It's a court ruling, and it is important for us to be able to disseminate the information in a way that people can really understand it. So we're hoping that you'll be able to help break down all the legalese for us this morning and make it a bit more understandable. So let's start off, I believe, with looking at the meat of the matter, the ruling coming out of the CCJ.
Okay, so the Belize Bank is the recipient of an arbitral award and sought permission from the courts in Belize to enforce that award in Belize. All right. That award, the process is you first go to the Supreme Court and you seek permission from the Supreme Court to register and enforce this award. What happened in this particular case, the bank did initiate a claim to enforce the award. The lower courts and the Court of Appeal, by a majority, ruled that in fact the Belize Bank could not enforce the award. The Belize Bank went to the CCJ, which is our final appellate court, and it's the short for Caribbean Court of Justice. And the Caribbean Court of Justice gave the Belize Bank permission to enforce that award as an order of the Supreme Court, of our court. So that is the ultimate outcome of the decision. Belize Bank now enjoys a ruling from the Caribbean Court of Justice, our final appellate court, saying that it can take steps to enforce its award in Belize.
Yeah. I think it's a great time to kind of explain how the judicial system works as well, because you know, we hear questions from people as to where do you go after this, which court can you take it to? Right. So let's discuss that.
All right. The Caribbean Court of Justice is Belize's final appellate court. There is no other court that can the parties can go to. All right. It's the end of the decision for the parties. All right. So Belize has hierarchy of courts. You first start at the Supreme Court. If you're not happy with the decision from the Supreme Court, you then go to the Court of Appeal. And if you're not happy with the outcome there, you go to the Caribbean Court of Justice, all right, which is the final appellate court.
And in this particular instance, in Tier 1 and Tier 2, the Supreme Court and the Court of Appeal, the government had won the case. But when it went to the CCJ,
right,
it was the Belize Bank who turned out to be successful in the claim.
Yes, but I must mention that at the Court of Appeal, the decision was not unanimous. The government won by a majority, meaning that the court was not unanimous. There was a dissenting decision. And the CCJ ultimately agreed with the minority decision.
Okay, so that's important to be able to understand as well. Now, stepping back into the history of the award itself, we have spoken about how this particular award has gone through other avenues, other jurisdictions as well. And it started off at the London, it was a London Court of International Arbitration Award, right?
That's correct.
Let's talk about that process and where it went from there.
Okay. So the government of Belize and the Belize Bank had entered into a settlement agreement. And in that agreement, both parties agreed that if there was any dispute, that they would pursue the avenue of arbitration. So the Belize Bank took its claim to the London Court of International Arbitration, And at that court, or at that tribunal, it was successful. And the London Court of International Arbitration found that the government of Belize was obligated to pay an arbitral award in excess of 38 million, I believe, plus interest.
Yes.
All right? And it is that award that the Belize Bank sought to enforce.
It was originally 20 million. At the LCIA, it became 38.
Right, because interest continues to accrue on the sums that were due pursuant to a loan note under the settlement agreement. All right.
And we know that following the ruling from the tribunal, we saw an immediate opposition to that particular ruling, and the government of Belize at that time said they were simply not going to adhere to it. And then it moved into what court at that point?
All right. Before
Kind
we
of
get
follow
there,
the line here,
the
yeah.
government decided that it would not participate at the London International Court of Arbitration. The
LCIA.
right,
Yeah.
the LCIA.
Yeah.
It would not participate.
So that's important to break down, because so John and I are in a dispute. We go to you, the judge, in this case, the LCIA, and I go to defend my case, and John says, I just won't go.
Right.
Is that what happened?
That was the position of the government. I'm not going
And so
to
the
participate.
case proceeded without.
It proceeded without the government's participation. And the London Court of International Arbitration, in fact, heard the merits of the claim and delivered a decision. So even though government did not participate, a ruling was made on the merits of that case. All right?
And that ruling at the time was?
That the funds payable under the loan note were in fact payable to the tune of 30-odd million Belize dollars at that time. So it is that award that the Belize Bank then brought home to Belize and, as they are entitled to under our Arbitration Act, to enforce it as a judgment of a court in Belize.
Now, this did not only go through the courts in Belize going up to the CCJ. It was also taken to court in the U.S. Right.
Yes.
Can we explain that process?
Well, before we get to that process, all right, let me just say that the challenge, and the reason I'm getting into this because I think this is the crux of what happened at the CCJ. When the Belize Bank sought to enforce the decision, government decided that it was going to resist the enforcement of the award on the basis that it was contrary to public policy. All right? Now, before even the London Court of International Arbitration, the issue of the same loan note had been litigated in our court system. If you recall, by the Association of Concerned Belizeans. And it had made its way all the way to the Privy Council, which at that time was our final appellate court. So just to give a backdrop, before the Caribbean Court of Justice, our final appellate court was the Privy Council.
So, and thank you, because that is such an important point as well, because it was also a part of the government's case going into the courts here in Belize in the enforcement of the awards, that essentially the decision of the government, the administration at that time to assume the loan note was an illegal action, and that's what ACB took to court. It was unconstitutional or against the public policy, right?
Right. They sought to challenge it. They said, look, that loan note and that settlement agreement is null and void because it is contrary to the laws of Belize. At that time, whenever any government borrows money in excess of 10 million, one has to go before the National Assembly. The Prime Minister and his cabinet could make a decision, I'm going to borrow 10 million, but to get the proper authority to do so, they have to table that table a motion before the National Assembly to get permission to borrow that money. So the ACB, for short, Association of Concerned Belizeans, challenged and said that settlement agreement, that loan note, was invalid because there was no legislative approval, no approval by the National Assembly. The Privy Council found that the loan note did not need legislative approval, that it was a valid note. It was a valid debt instrument. All right? Because it found, and it's very technical, but just it found that basically government was not borrowing. Under the settlement agreement, government was settling certain liabilities, and in consideration for settling those liabilities, it had promised to pay by the loan note these funds. So it was not borrowing per se, it was settling certain liabilities that it had. Ultimately, the Privy Council found, and the Privy Council went into the merits of whether this loan note was valid pursuant to the laws of Belize, and it found that it was. All right? Now, when Belize Bank now sought to, went before the London Court of International Arbitration, after that challenge, it got a decision that the government was obligated to pay in excess of 38 million. Then it sought to enforce that award here in Belize. The government again sought to resist that award using the same arguments, basically, that in fact it is against public policy to enforce this award because there was no legislative approval. So it sought to reformulate the same arguments it made in the ACB case. Well, what the ACB made, and it was against the government. And the Caribbean Court of Justice said, look, you already have a decision from your final appellate court at the time finding that this is a valid loan note. You cannot bring that argument here to Belize, to us again. Furthermore, in the courts below, the attorney at the time for the government of Belize, Dennis Barrow, had in his statement of issues conceded that the Prime Minister at the time did not need legislative approval for this, for entering into this loan note. So the Caribbean Court of Justice said, look, you cannot relitigate that issue before us. There is another decision from your final appellate court saying that, look, we have you, the Belize Bank has a valid loan note. All right? So ultimately, the Caribbean Court of Justice gave Belize Bank permission to enforce their note. All right? So the decision basically is that you, Belize Bank, yes, you have permission to take steps to enforce your arbitral award in Belize.
Now, the government of Belize has obviously expressed their shock at the ruling coming out of the CCJ, and particularly because they were successful in the Supreme Court and successful by way of majority at the Court of Appeal. On what grounds were they successful?
They were successful because they had argued that whereas the Privy Council had found that the loan note, the executive had the authority to enter into the loan note, that decision could not be interpreted as also translating to enforceability. Because you still need permission from the National Assembly to enforce that decision. So the lower courts agreed with them, except that there was a member of the Court of Appeal that disagreed with their position and said, you are confusing the issues here. What is before us is the Belize Bank seeking to register its award. There is, and to take steps to enforce, right? We're not there yet, right? So, and the CCJ said that when you are determining whether to give permission to allow a person to enforce, yes, public policy is an issue to factor in, but that issue had already been determined.
Yeah.
You government had, by your attorney, conceded that point. All right?
So your attorney agreed with what came out of the prior ruling with the government versus ACB, which was that the loan note was valid.
Right.
So it is so complex to be able, because of all the history around it. And the history is one thing. There's a lot of public sentiment about the issue because of what we're talking about.
Right.
With the ruling that has come out of the CCJ, and as we've said very clearly, this is where the buck stops, essentially, if we use a very common term. There's no higher court that you can go to.
Correct.
We are now seeing the playing out of the decision-making process, if we can call it that, of the government of Belize as to how to handle the particular ruling. Yesterday at the press conference that the government hosted, we are having clear indications that it will go to the House and that there is more than likely going to be a failed motion. Talk to us about what this means.
Okay. All right. So the Caribbean Court of Justice gave permission to Belize Bank to enforce. So Belize Bank now needs to take steps to enforce. And as the Honorable Prime Minister explained in his press conference, there is a procedure to do so. After the expiration of 21 days, the Belize Bank then applies for a certificate before the registrar and then serves that certificate to the Minister of Finance, who is in charge of dispersing funds under the public's purse. All right. So that step needs to be taken. Now, for the Prime Minister to pay monies, he needs permission from the National Assembly, and that is a requirement under Section 114 of the Constitution. So the Prime Minister and several of the legislators have publicly indicated that they will vote no, and that they will vote, they call it a conscience vote, that their constituents have authorized them to vote no. Problem with that is that we're no longer seeking authorization to sign this loan note and bind the government of Belize. We have a judgment saying there is a valid loan. There is a valid loan note, a debt payable by government of Belize. That issue is long gone. The legislative body under Section 114 has the power to appropriate funds, to give permission for the payment of monies out of public funds. And it does so by an appropriations bill. All right? The issue that will be before them is not a conscience issue anymore. A final appellate court has already determined that there is a valid loan note. So there is no longer room for a conscience vote. There is simply a decision to make looking at budget and finances as to appropriating funds to pay. It may not be able to pay all, it may be able to pay some, and so there will be an allocation for that payment at the time that motion is tabled. And let me just say that because we're beyond that issue, and you see it is not like the legislature can defy a court order and act arbitrarily.
Well, that is the impression people are having
Right.
at this point, as we hear, especially from the ministers.
Right. And it's very interesting to listen
From a legal
perspective because we are beyond a public policy issue anymore. And let me just say that, yes, your constituents could tell you, look, when you appropriate funds, I don't want you to pay this public officer or allocate for that department because that department is corrupt. I mean, your constituents can tell you anything, but that doesn't mean that you can act arbitrarily. You have to act. You have a responsibility. And the government right now has, in the face of it, a valid loan note.
So I've tried to break down this issue as best as I can in speaking to people. And essentially the point we're at is we've been mandated to pay. You owe it. This is what you owe.
Right.
And now we're at the permission of asking to take the money out of the purse.
Right.
Now, is there a possibility as to having a payment plan in place? Is that also something that can come out of this? Would it be possible for or government now to say, listen, we cannot pay, will not pay $90 million at this time, but perhaps we'll be able to do tranches, or are those applicable under the enforcement?
Yes, those are applicable, but let me just say, and before I get into that, I think it is important to address, okay, yes, the legislative body has a duty and responsibility in the face of this valid loan note. But let's say they decide to vote against the payment. Then if they decide to vote against the payment, there are other avenues available to the Belize Bank. It is the legislative body, because our constitution is supreme. Parliament is not supreme. The National Assembly is not supreme. It cannot defy a court order. It cannot seek to relitigate this issue by voting no. All right? So if it votes no, that would be tantamount to an arbitrary deprivation of property. Which means because I have a valid debt, you decide you are going to withhold funds and not pay me. That decision by you, in effect, amounts to an arbitrary decision by you to deprive me of a valid debt that I have. So that what the Belize Bank can ultimately do, because this Constitution of Belize is supreme, not Parliament. The arbitrary deprivation of property is a breach of a fundamental right. And the Belize Bank can go before the courts and bring a constitutional claim and said, by Parliament refusing to pay, allocating funds to pay, and taking a deliberate decision not to pay, this is an arbitrary deprivation of property. And ask the court to fashion a remedy to declare that it is so and to award damages. Those damages would be to compensate them for what their loss, which would be their arbitral award plus interest. Once the Belize Bank has such a declaration, and if the court agrees with them, then the Supreme Court of Belize has, under Section 20, the power to fashion a remedy to compel the government of Belize, the Minister of Finance, to pay that money.
But I think this is where there is a lot of questions, because even if there is a ruling to say the Minister of Finance must pay, he is required by our law to still take it back to the House.
Right. But it is not like the National Assembly can willy-nilly, arbitrarily vote no. They cannot. I've heard this policy, public policy, it's not in the public interest. That issue has already been determined by a court.
It has been conceded by the government lawyer.
Because you would end up with Parliament being supreme and being the final appellate court if the buck stops with Parliament. If Parliament could say, I'm not going to pay because it's not in the public interest, then you're relitigating an issue that a court has already made.
But what are the...
Has already made a decision on.
From the impression that has been given at this point, it seems to be an act that the ministers and the government feel that they can do at this point. So what happens with the public proclamation at this point that we're making this decision because it is against public policy, it's against what our constituents are asking us to do, because we feel that the loan note was invalid, and we make this decision to vote no? What does that mean?
We're beyond that. We're beyond that. And members of Parliament must act responsibly. We have a debt obligation that is not going to go away. And in the meantime, interest continues to accrue. The responsible thing is to pay, because the longer you pay and kick it down the road, the more this debt mushrooms. As we have seen, it started out
At 20.
with 20 million, and now we're at
90 million.
Right, 90 million. So Parliament must do what is the responsible thing.
But
if they decide to defy, there are the court, the parties can go back to the court. And in the meantime, it's litigated years and years again, as we've seen. Interest continues to accrue.
And that's one of the things that I wanted to touch on in terms of okay, there's a vote no, the duration that would eventually come out of it. Now, let me tell you what I understand from the entire thing here, and this is public sentiment. It seems to be a UDP, PUP war, whereby you did something, we're going to leave it like that, even though they know, or government knows that this is something that we have to do. The ruling have already been sought down from the highest point possible. There is no other place you could go. They said, hey, you need to do this. They're saying, no, we don't think that we have to do it, or we won't do it because then it was them. And this is what drives the public crazy, because they're followers that are blue, they're followers that are red, and these guys are fighting against something that they know that they have to do. In the case they vote no, and they won't pay, or they say, you know what, we're not going to pay. The duration, or the government, the duration of time that in terms of, because of the rollover of monies, these things, eventually interest comes up. What's your duration of time? Within this particular party's ruling, or it could jump into the other? If in the next coming election, the blue should take over. Right.
So, look, there has to be continuity, and governments, successive governments, must respect decisions and policy, as wrong-headed as they may be, and I'm not here to discuss the merits of what went happen. But if successive governments were to decide to not honor previous obligations, we would have anarchy. Nobody will want to do business with Belize, because it depends whether you're with the blue or with the red. We've seen this time and again with change of governments, where there is a contract and there's a change of government, and the new government decides it's not going to honor, and ultimately it has to pay. So it is not like you could get away because there's a change in administration with not honoring obligations of past governments.
So what you're saying is this debt is inescapable, whether 90 million today, or I think even the Prime Minister joked $1 billion later on down the road. It will still be there as something owed by Belize.
Yes. And in the meantime, interest continues to accrue.
But there's a bigger issue beyond just a growing interest and having to pay more money back to the Belize Bank. The issue of rule of law and the separation of powers is one that is really coming into the question at this point in time. If I go to court and the court rules, and it goes all the way up to the CCJ, that I have to pay $500, if it's just that, I have no choice but to pay. We are supposed to be law-abiding citizens. If we are to replicate that as to what is happening now, it is our leaders saying, the court is saying this, but we simply won't do it. What does this mean for rule of law, and what is the separation of powers here?
Right. It undermines the rule of law. And it's interesting that you brought up that point, because the Caribbean Court of Justice, the Belize Bank had asked for an order mandating that government pays, that the Minister of Finance pays. And the Caribbean Court of Justice says that's premature at this stage. You have to give, there has to be a presumption of regularity. We have to give the government the benefit of the doubt, the benefit that it will do the right thing. If it decides to defy the court order, then you, Belize Bank, will take, well, it's open to you to take certain further steps, right? So that the Caribbean Court of Justice expressly mentioned, we have to presume that Parliament will do what it should do. And at this point, we're not going to decide, we're not going to give you an order to mandate that the Minister of Finance pays this, right? So that the Caribbean Court of Justice, like anybody from Belize and who understands that our Constitution is supreme, assumes that Parliament will act in good faith, that Parliament will take its responsibilities seriously and do the right thing. We are beyond a conscience vote at this point in time.
Now, what are, let's talk the two scenarios. That the House votes no to the motion, which there seems to be a clear indication. And there's also very specific wording the Prime Minister used yesterday that I find very interesting on a personal level. He's saying he doesn't know how they're going to vote. They're saying no, but it's yet to be seen. But I think our general understanding is, from what we've heard from the ministers, from the declaration made yesterday by the Prime Minister, that they're going to vote no, if and when this is taken to the House. What are the possible ramifications following that? So you have what it means in terms of a government's action and what it means for the possibility of courses of action for the Belize Bank.
Right. So if Parliament decides to vote no, the Belize Bank has the right to challenge, to continue, and to say, by Parliament voting no, Parliament has arbitrarily deprived me of a debt that is owed to me, and bring a constitutional motion and invite the court to fashion a remedy. And it is open to the court to fashion a remedy, to compel the Minister of Finance to pay. And our final appellate court, the Caribbean Court of Justice, in several cases have said that, look, when a party seeks constitutional redress before us, we have the power to fashion a remedy. We can compel the executive to pay. We can compel the executive to do certain things. So that it doesn't mean that because the National Assembly votes no, that's the end of it. It just means further litigation, more interest, and more cost to the Belizean public.
Yeah. And the cost of the legal fees have already been awarded to?
I'm not sure, because I'm not involved in the case.
Now, in terms of what it means for a government to act against their highest court, what are the ramifications of that? What does that mean in the international community, in the legal community? What does that represent?
Well, I think that it, as you had raised earlier, it undermines the rule of law. It shows defiance And defiance meaning you're not willing to respect. You've lost. You've lost, and you need to respect the outcome of that decision. In terms of the wider international picture, it gives off a wrong message, right? This is not about the Belize Bank. This is about investors, people doing business in Belize, willing to come into Belize and invest, seeing that you have governments who think that they can get away. And we've seen the governments try to legislate their way out of problems. But ultimately, the court can strike down legislation. Ultimately, the court can fine you to be in breach of someone's fundamental rights. So, but in the meantime, it conveys a message that, look, you know, a government or this government thinks it can get away, can defy a court order, and it's not good, because people wanting to do business want to know that if there are successive governments, that whatever debt obligations or any obligations owed to them, that it will be respected.
Senior Counsel, I want clarity on a particular issue, because yesterday the Prime Minister joked as to whether or not jail time is a possibility as the Minister of Finance. What is the, can you provide some clarity on that particular issue?
Well, that is definitely in terms of enforcement proceedings. Let's say, for example, if Parliament votes no, the Belize Bank brings a constitutional motion. The courts agreed that by Parliament voting no, there is an arbitrary deprivation. And the courts order that Minister of Finance pays. The Minister of Finance has to pay. And at that point in time, the court, if he does not, it's open to the Belize Bank to go to the court to cite him for contempt of court. And if it goes to that point, then yes, the Minister of Finance can be in prison, because the court, the Constitution is supreme. Nobody is above the Constitution, and you have to respect it.
But while possible, it's not likely?
Well, that's
like far down the road?
Yes, that's down the road, and one would hope that you know, good sense will prevail ultimately.
If you know, when we hear the public speaking of this issue, I think the core concern that people still carry today is the origin of the loan note. And from what you have explained, I believe we've spoken about how the validity of the loan note has been established from the Privy Council, reinforced by the Belize courts, and even accepted by the government of Belize attorneys in their presentations. How do you explain, if you can, to the Belizean public that the issue of where it started, how it started, because there were really two decisions that were made in this issue, if I am to break it down. There is the decision of the loan note, which went through the court system. And there was a decision, that was by the prior administration, the Said Musa administration. Then there's a decision by this administration to, instead of paying what it was at that point, to legislate or to have a failed attempt at undoing this in the court, which has now taken it from 20 to 90 million. How do you simplify this issue to Gina and Joe public as to what it means for the court ruling to be honored by a country? Why it's necessary, why we need to kind of let go the fact that it went to court and accrued all this interest, that there was the loan note in the first place. How do we simplify this?
Because we have to, as good citizens, as parliamentarians, we have to obey decisions of our court system. It is how we are able to establish law and order in this country. And if you do not, if you defy a court order, it undermines the rule of law. It can lead to anarchy. So that to Joe Public, yes, you may not agree with what happened by the previous administration, but you have to respect our court system. You have to be willing, as good citizens, to comply with court orders. If not, law and order is undermined, and we can lead to anarchy, right? If people, instead of going to court, start shooting each other because they have a grievance. I mean, you know, we have to go to court. We have to comply with court orders. It is what makes things function, ideally, in a country. Right. Citizens being willing to abide by the law and decisions of the court system.
Okay. Well, thank you for that final point in terms of being able to break it down for all the rest of us. This is an important issue, and we really appreciate you coming in to break down the legal aspect of it.
Right.
Right? Thank you.
You're welcome.
We're going to go ahead and take a break, and then we come back.
Yeah, when we come back, we'll be talking Inter-American Development Bank and Ministry of Education on Education Quality Improvement Program. That's coming up when we come back.